Period 2, Mr. Uday Kumar.
Yes.
Very pleased, my lord.
Yes.
This is another renewal of prayer for bail, my lord. I would just like to draw my lord's attention to the last rejection order, which is at page 20, my lord. Some observation had been made by this honorable court, my lord.
Yes, and you're in custody since when?
My lord, since 3/6/2013, my lord. That's almost nearing 9 years, maybe 20 days less.
No response is needed, Mr. Dilip. No response is needed, though he is one of the assailants, but nonetheless, he has remained in custody for 9 years.
The case is under section 364A/302, my lord.
All right, 9 years. How many years we'll keep him? We are not hearing the appeal.
Yes.
Look here. Heard Mr. Kumar Uday Singh, learned advocate for the appellant applicant, and Mr. Dilip Narayan Singh for the state.
Dilip Kumar Sinha.
Dilip Kumar Sinha. Dilip
Yes.
Kumar Singh or Sinha?
Sinha, my
Dilip Kumar Sinha for the state. The appellant applicant has renewed his prayer for suspension of sentence and grant of bail during the pendency of this appeal. More than the merits of the case, Mr. Kumar Uday Singh, learned advocate, has drawn the attention of this court to the fact that the appellant applicant is in custody since 3/6/2013 and thereby has spent approximately 9 years in custody. He further submits that there are no chances of this appeal being taken up for final hearing in near future. We are definitely reminded of the observation of the Honorable Supreme Court in Kashmira Singh versus State of Punjab, 1977, Supreme SCC 4291, that no practice, howsoever sanctified by usage and hallowed by time, can be allowed to prevail if it operates to cause injustice. The practice of not releasing accused persons, not releasing convicts on bail post conviction, is primarily based on the postulate that the appeal shall be heard within a measurable distance of time, and that a convict should not be let loose before his conviction is set aside. However, finding that this appeal has not been heard for all these years, we find no justification of not suspending the sentence of the appellant applicant during the pendency of this appeal. Similar approach has been adopted by the Supreme Court towards holistic disposal of such cases in Saudan Singh versus State of UP. Iska reference le lena. This is a criminal appeal number so and so, SLP number so and so.
I can give the numbers.
Having regard to the aforenoted circumstances, we are inclined to suspend the sentence of the appellant during the pendency of this appeal. The appellant applicant is directed to be released on bail on his furnishing bonds in the sum of ₹10,000, 2 sureties of like amount to the satisfaction of the trial. उसके ऊपर लिखेगा Mr. Kumar Sinha, learned counsel for the state, submits that in view of the aforesaid, in view of such long period that the appellant has remained in custody, there would not be any necessity of